Start. Para. Being aggrieved by the judgment and order of conviction dated 24/7/2017 by learned judicial magistrate, first class Dhanora, in summary criminal case number 76/2016, this appeal is preferred. This appellant was accused in SCC number 76/2016, so parties will be referred to as per their original status hereinafter. Para. It is the case of the prosecution that on 4/9/2015 at 6:30 p.m. informant had been to Gram Panchayat Tubewell, which is in front of Village Panchayat 1 PW3 and PW4 were accompanying her. They all returning to their house with pitcher with them. Accused suddenly came in front of the victim on main road opposite to forest office. He caught hold the hand of victim. Victim threw said pitcher over the accused. Then accused caught hold her neck. Informant gave jerk to the hand of the accused, due to which her salwar torn. Victim also slaps accused. PW3 and PW4 also tried to rush towards the accused, so he ran away. Victim sustained injury over her neck. She narrated incident to her father. No transport facility was available to reach police station on that day. Then she lodged report to police on next day. Para. It appears that the victim was medically examined. On the basis of the report, crime was registered wide crime number 36/2015. During investigation, Head Constable Sri Hari drew spot panchanama and seized salwar of victim. After completion of investigation, he prepared charge sheet. Para. After recording evidence of witnesses and upon hearing the parties, learned judicial magistrate first class Dhanora was pleased to convict the accused for the offence punishable under sections 354 and 323 of the Indian Penal Code. This appeal is preferred on the ground that the evidence of witnesses is not properly appreciated. The trial court should have considered that there was no evidence regarding outraging of modesty. The trial court should have considered the admission of victim that there were no talking terms between victim and the accused. The trial court should have also considered that there was considerable delay in filing FIR. Para. Learned advocate for the accused has submitted that Panch Lokmitra is from village Nimgaon and incident took place at village Rangi. The distance between these two villages is about 3 to 4 km. According to him, investigating officer has submitted that he has called two panchas from village Rangi. This witness Lokmitra is relative of the victim, so he is interested witness. It is also submitted that the oral evidence of the victim is contradictory to the contents in FIR. It is also submitted that statement under section 164 of CRPC is also not consistent with the report. He has reported case of Bhanu Singh versus State of Chhattisgarh 2022 SCC. Para. Learned APP has submitted that the accused has just put suggestions regarding animosity between victim and the accused, but those suggestions are denied. Evidence of victim is also supported by PW 3 and 4. The evidence of Dr. Amol shows existence of injury on the person of the victim. It corroborates ocular evidence, so order of conviction is proper. Para. It is well settled that prosecution has to adduce cogent and convincing evidence to prove guilt of the accused. It is also well settled that sole testimony of informant or witnesses is sufficient to base a conviction, but a rule is that it should inspire confidence in the mind of the court. If a single grain of doubt appears in the prosecution story, defense gets benefit of it. In order to prove guilt under section 354 of the Indian Penal Code, following ingredients are to be proved. First, that the person assaulted must be woman. Second, that the accused must have criminal force on her. And third, that the criminal force must have been used on the woman intending thereby to outrage her modesty or has knowledge that modesty will be outraged. Stop.